Alrighty, party peoples of the interwebs. I've got one take to get this video because the phone is going to go dead because we're in subarctic minus 18 degree temperature. It is only fitting that I will review Judge Juan Marchand, the commie judge out of commie New York State, decision back in commie Canada behind the maple gulag, rainbow, iron curtain rainbow. You know what it is, people. Viva Frei, former Montreal litigator turned current Florida rumbler, obviously not in Florida anymore, Toto. I'm back in Canada, and it is Christmas morning, so Merry Christmas to everyone out there who's celebrating, and Hanukkah actually falls on the first day of Christmas this year for the first time in like 60 years, so happy Hanukkah. And to celebrate, we've got the outrageous mental gymnastics, arguing from conclusions and not towards them, motivated reasoning decision from Judge Juan Marchand, the totally not corrupt judge whose daughter is not working for Authentic HQ, taking in millions and millions of dollars fundraising off of Judge Juan Marchand's persecution of Donald Trump out of New York State. You all remember a certain Supreme Court decision coming down, I think it was July-ish, on immunity, presidential immunity, and it caused the left and blue checkmark, capital D Democrat talking heads on propaganda outlets to go nuts. Presidential immunity, now the president can literally assassinate his rival and be immune if it's within the core constitutional acts of president. These are the same people who flipped out when Dobbs' decision came down and overturned Roe versus Wade. And then everyone thought, holy crab apples, Trump got his abortion ban, where what you actually had was not an abortion ban whatsoever, but rather the Supreme Court kicking the question of abortion back down to the states, which is what states typically want, is to decide their own issues on abortion. Okay, fine. The Supreme Court came down with the immunity ruling, which, understood properly, which it seems that many propagandists out there don't understand this decision properly. Understood properly means for core constitutional acts, duties of a president, there is absolute immunity. For purely private acts of a president, you know, like killing a chef if you don't like his food, I'm not making any references, I'm just using a hypothetical, there would be no presidential immunity because that would be a purely private act. For acts which are ambiguous, you need to do an analysis as to whether or not those fit within the acts, duties of a president, and there's presumptive immunity but not absolute immunity for those that fall within the middle of the spectrum of purely personal, core constitutional. All right, that's on the immunity issue. That decision cast into doubt a number of persecutions facing Donald Trump, but it wasn't just the immunity ruling from SCOTUS that was relevant, especially as relates to this unreal decision coming from corrupt Judge Juan Marchand in New York. The Supreme Court also adjudicated on the admissibility of evidence. And there would be, even if it's a purely personal act, there would be immunity or at least inadmissibility of evidence that relates to presidential duties, presidential acts. And therefore, if the evidence was adduced in violation of presidential acts, even if it's to prove a purely personal violation for which there would be no immunity, such evidence would not be admissible. All right. Flashback to New York State now, where Trump is facing that 34-count conviction on the hush money payment, a bogus conviction of a bogus prosecution that was outlandish from the get-go. At worst, it was a misdemeanor that would have been time-barred, except they found a way to marry it with felony violations so that they could extend the statute of limitations and prosecute as a 34-charge felony what would otherwise be a misdemeanor at worst, but we're not in a normal universe anymore. Trump was convicted, 34 charges, he's a convicted felon. Oh my goodness, the left had an orgasm when they had that headline to run with for months. Trump had filed a motion to vacate the verdict. Now, I like to highlight my predictions that come true, and I also like to highlight the ones that do not come true, because every now and again, I get them wrong, but only because I cannot predict the depths of the depravity and corruption of a system that is supposed to work on the basis of the law. That movie, The Happening, M. Night Shyamalan, pretty crappy movie, but the idea was that at some point in time there was this plague and humans lost the ability to self-preserve. Judge Juan Marchand has lost the ability to legally self-preserve his own judgments from his own improper reasoning, his own political bias, his own political prejudice, to the point where I can't predict reasonably what a rational judge would do because Judge Juan Marchand is not a rational judge. He came down with the decision. It can only be described as the most quintessential example of motivated reasoning you'll ever see, arguing from conclusions and not towards them. What is the conclusion to which Marchand needs to arrive if he wants to maintain this conviction against Donald Trump? He's got to come to the conclusion that the acts that Trump was accused of are purely personal acts for which there's no analysis necessary to determine if they are presidential or presumptively presidential. So they need to be purely private, and then, as relates to the admissibility of the evidence, it needs to be that the evidence was not adduced in violation of the immunity rule as relates to evidence by the Supreme Court. And then you have to get past the question of whether or not Trump preserved his objections properly. So knowing that that's the conclusion to which Judge Juan Marchand, the totally not corrupt judge whose daughter's making millions off his prosecutor Trump, knowing that's where he needs to go to, you need to know how to get there. How do you get there? Exactly as Judge Juan Marchand does. He gets past the first stage as to whether or not the acts that Trump is charged with or accused of in that case are presidential, presumptively presidential, or purely private, and they come to the conclusion, the judge does, that they're admittedly purely private, therefore that element of the analysis need not be addressed. Purely private acts, therefore the immunity for presidential acts as relates to the Supreme Court ruling doesn't apply. Now we need to get to the evidence. There was evidence, not to go through all of it, because the judgment is 41 pages of mental gymnastics. There was evidence of correspondence between him and Michael Cohen, his attorney, between him and Hicks, the press secretary. There were evidence of him communicating with staff, White House staff, while he was the president. How is Judge Juan Marchand going to get past whether or not this is private or not private, and therefore inadmissible evidence, the way you think he would? When it relates to whether or not they were properly preserved, the objections, I think all of the objections, except for maybe the ones with Michael Cohen, were properly preserved. But the judge says even if they weren't properly preserved, they wouldn't benefit from the immunity in the Supreme Court ruling. When it comes to the evidence, the judge says, yeah, I know the Supreme Court said that the evidence that is of presidential acts is inadmissible. None of this was. All of this was done in furtherance of a purely private act, and therefore it's purely private evidence, no analysis really necessary, and therefore all of it is admissible to the point where there was nothing unlawful that was done during that trial that would warrant vacating the decision, vacating the verdict, vacating the conviction, which is what Trump had filed a motion to do. Trump filed a motion, says that evidence was inadmissible, admitted in violation of the Supreme Court ruling as relates to the admissibility of evidence, and therefore you need to vacate the verdict, throw it all the way back, and that would be done with it. I predicted that Marchand was in fact going to vacate the verdict because he would get to blame vacating the verdict on the Supreme Court, say, my hands are tied, I would have sentenced him to whatever. I've said this many times, that the judge, Marchand, if he had the slightest bit of legal self-preservation in mind, or if he weren't so blinded by his own political animus, he would have said, my hands are tied. The Supreme Court says I have to do the analysis as relates to all of the evidence. I can't really do that. We're going to have to vacate the verdict. I would have otherwise maintained it and sentenced Trump to whatever. I thought he was going to do that. What he gets out and does and says, no, none of that evidence violates the admissibility of evidence as relates to presidential acts, because even the correspondence between Trump and his White House staff when he was president is not presidential communications that is inadmissible. It's insanity. And the judge covers his tushy like the most corrupt judge would cover his tushy. He says, look, all of the evidence was purely private acts as relates to purely private acts of accusations against him. Therefore, it's not inadmissible, even pursuant to the Supreme Court ruling. But even if it were, that it would be so harmless, that the error would be so harmless, it would be allowed nonetheless, given the preponderance of the guilt of the accused. This is literally what he said. I'll read you a segment from the decision because it will blow your mind, where you will not be able to understand that there's a judge on the bench who is so judicially corrupt that would do this level of mental gymnastics to reaffirm an unlawful conviction of an unlawful process, of an unlawful persecution of the president who has just been reelected. The judge literally said all of the evidence adduced, purely private communications, not presidential, even though it's between president and White House staff while he's president, in furtherance of a purely private act of the hush money payment concealment, which would have been a misdemeanor in any realm of the universe. and therefore it's admissible, and therefore we're not vacating the verdict. But even if it weren't admissible evidence and were indeed adduced in violation of the Supreme Court rulings, it's such a minor, harmless error that it would stand nonetheless. That's how he got there, people. So he has not vacated the verdict, and corrupt Judge Juan Marchand is dragging on this process, kicking it to the Court of Appeals, pretty much similarly to, although much more corrupt than Judge Scott McAfee out of Georgia, who got all the facts right, just got the conclusion of law wrong, possibly because he was running for election and didn't want to shoot himself in the foot, possibly because he lacked the judicial cojones to do it, kicked it to the Georgia Court of Appeal that said, yeah, Judge McAfee, all of your facts were in fact right, which makes your conclusion of law overturnable by the Court of Appeal. The Court of Appeal in New York State had better overturn this judicial corruption coming from Juan Marchand, because it is discrediting to a state, to a judicial process, to an American legal system as a whole. They had better overturn Judge Engoron's ridiculous $450 million disgorgement plus interest ruling in the Letitia James persecution. They had better do it to preserve the system, and more importantly, to preserve people's faith in the system. Because if people lose faith in the system, even if it starts working properly again, and I'm not sure it will or ever can, people will never have faith in it in order to trust it, and that is how society breaks down. So that is the summary of the ruling. I will read you a highlight now. Merry Christmas. If we don't speak before New Year's, although we will, regardless, Happy New Year. It's beautiful. Freezing my tushy off because this log, was outside and it's cold. Viva Frei. Make sure that you are liked, shared, subscribed, turn on those notifications, and enjoy the sound of wonderful silence. Mic drop. As relates to the testimony of Michael Cohen, the court writes as follows. As previously noted, the objections to Mr. Cohen's testimony were unpreserved and thus unreviewable. Nonetheless, as an alternative holding, this court finds that the argument also fails on the merits because his testimony reflected unofficial conduct and no level of immunity applies. Even if the testimony did pertain to conduct falling within the outer perimeter of his presidential authority, subject to presumptive immunity, this court finds that the people have once again rebutted the presumption without invoking the motive for the conduct. And as relates to the admissibility of the evidence, these gems. Even if this court did find that the disputed evidence constitutes official acts under the auspices of the Trump decision, which it does not, defendant's motion is still denied as introduction of the disputed evidence constitutes harmless error and no motive proceedings error has taken place. A little bit further on in the decision, this court concludes that if error occurred regarding the introduction of the challenged evidence, which it does not, and such error were excised, such error was harmless in light of the overwhelming evidence of guilt. And then the cherry on the top of this insane judicial sundae at the end. Further, even if this court were to deem all of the contested evidence, both preserved and unpreserved, as official conduct falling within the outer perimeter of defendant's presidential authority, it would still find that the people's use of these acts as evidence of the decidedly personal acts of falsifying business records poses no danger of intrusion on the authority and function of the executive branch, a conclusion amply supported by non-motive related evidence. And lastly, this court concludes that if error occurred regarding the introduction of the challenged evidence, such error was harmless in light of the overwhelming evidence of guilt. Defendant's motion to dismiss the indictment and vacate the jury verdict pursuant to CPL 330.31 is denied. The foregoing constitutes the decision and order of the court. Judge Juan Marchand, the totally not corrupt judge whose daughter is making millions off of his persecution of Donald Trump.